Usually, it's the defendant that's in trouble in the courtroom. But when a detention officer takes a privileged document from a defense attorney's file without permission, his courtroom decorum gets him in trouble.
I want to know what they took, why they took it, and what's going on.
I think you should just take a deep breath and calm down here.
October 2009, Phoenix, Arizona. Defense attorney Joanne Cuccia speaks before a judge during a sentencing proceeding when detention officer Adam Stoddard makes his way to the counsel table behind her.
Sometimes the detention officers or deputy sheriffs would stand near you as if security required it. My focus was on my client, his legal proceeding, and getting through that.
Stoddard begins to look over a privileged document in Cuccia's case file.
I left my file on the table behind me and presumed that no one was going to touch it. There was a handwritten letter that was not fastened in the file. It was loose, and I believe there was about 1.5 to 2 inches of the letter sticking out.
The officer pulls the document out a few inches to get a better look at it.
I'm not certain why Mr. Stoddard was interested in the contents of my file. I don't know what he was doing.
After a few moments of reading, Stoddard motions for another officer to come over. As Cuccia continues her statement, Antonio Lozano, the defendant, who is being sentenced for assaulting another inmate, notices the activity behind him but doesn't say anything. Then, Stoddard removes the document from Cuccia's file and examines it, a potentially serious breach of attorney-client privilege. He instructs the other officer to go and make a copy of it. As that officer leaves, Cuccia turns around, but is unaware of what they are doing with the document.
I think he did give me like the it's okay look, and I probably turned back.
Cuccia resumes speaking to the judge, who does not seem to see the officers taking the document either. But Lozano finally brings the matter to the court's attention.
I was shocked and surprised. I had to protect my client's rights, and that's first and foremost what I had to do, and so that was my focus.
Cuccia requests a sidebar to explain her concern to the judge.
Judge, newly approach.
Adam, could you come up for a second?
It's not something they train you for in law school on how to handle a situation when something's stolen from your legal file by a member of the courtroom.
But when she returns to the podium, Cuccia is clearly upset.
Judge, may I just say that any letters I received from Mr. Lozano, I've received through regular jail mail. Number one, it was, of course, privileged in my file, handwritten from my client to me, but it also had a date stamp on it, which indicated that it was sent to me. Excuse me, I don't mean to be disrespectful, but this is the first time in 10 years of practicing law that this has ever happened to me. I want to know what they took, why they took it, and what's going on.
Deputy, can you give us any clue about, was something taken right off the podium in front of the defense counsel?
I need to hear about having my file a work product. If I'm being accused of any kind of wrongdoing, I want to know exactly what was taken, why it was taken without my permission.
Ms. Cuccia, I think you should just take a deep breath and calm down here a little bit, all right?
I was probably thinking, well, I am calm. But, you know, a judge's job is to maintain decorum in the courtroom. She wasn't the person I was focused on being upset with.
You took something off of the counsel table, Deputy? I just want to know what's happening. That's all I'm trying to figure out.
Handwritten letter that was taken out of the file.
You don't get to do that.
All right. I do want to just say for the record that the deputies in my courtroom are responsible for courtroom security.
I agree.
And they have quite a lot of leeway to do what they think is necessary in a situation. Sitting here, I'm not sure what exactly is going on either.
How can, you know, a letter in the courtroom be a security violation or breach or emergency? I'm not allowed to go into my things. I was searched on my way into this building, and if they had any questions as to the contents of my file, I'm certain they could have asked me.
All right. Well, that's something we can address possibly at another occasion.
A few minutes later, the hearing breaks for the day, but this matter is far from over. This unusual public record video quickly finds its way to the web and causes a stir. Law bloggers from around the country take notice, including Arizona lawyer Matt Brown.
Well, I think it's pretty remarkable that a deputy in court helped himself to a defense lawyer's file on video. Not only did he have a look, but then he pulled the paper out and ended up making photocopies.
In testimony following the incident, Officer Stoddard defends his actions. saying that his concern was for the security of the court and that he had reason to believe that the document suggested Mr. Lozano intended to commit a crime.
I don't see any security threat that would justify them taking a simple piece of paper out of the file. He should have told the judge, Your Honor, I saw something that gives me security concerns. I'd like to look at it further.
During subsequent hearings, the court finds that there is no security threat justifying Stoddard's removal of the documents from Cuccia's file, and he is found in what's called indirect civil contempt, a violation of a court order outside the immediate presence of the court. A judge orders Stoddard to hold a press conference and publicly apologize to Cuccia for removing the document from her file, or else go to jail. Attorney Craig Marins represented Cuccia's interests at the hearing on the order to show cause. He agrees with what the judge decided.
I thought his ruling was very thoughtful, and I thought his sanction really made sense, made common sense. All he said is, just say you're sorry. That's all you have to do.
But that's not what happens.
Judge Donahoe has ordered me to feel something I do not. He has ordered me to say something I cannot.
I think it was incredible, just because he was very defiant.
I cannot and will not apologize for putting court safety first. The judge has therefore put me in a position where I must lie or go to jail. I will not lie.
Silly us, we thought that he was going to follow the judge's orders.
Of course, we were disappointed. I think an apology would have been sufficient on my end. I certainly didn't want to drag out the issue any longer.
Without the apology, the judge orders Stoddard to jail.
I remember reading all the news articles about him doing it in the Mesa Hilton, I think is what they call it, which is some kind of nice jail facility.
The Arizona Court of Appeals vacates the sentence but upholds the contempt charge. After spending 10 days in jail, Stoddard is released pending the outcome of his appeal. He immediately returns to work in the courts and later attends a class on attorney-client privilege. As for Cuccia, she has left the county and put this incident behind her. In more than a decade of law practice, this remains one of her most unusual experiences in the courtroom.
I think if the event happened and it wasn't on videotape, obviously it would be so much less of a story. But, you know, you can say that a detention officer took something out of an attorney's file, but when you see it, and I think it just has a bigger impact.